Well, good morning, everyone, and good afternoon for those of you that are further east, because I know there's people online today from as far away as Newfoundland and perhaps even further. My name is Paul Conway. I'll be your host today for the ADRIA FOAJ Luncheon. And I just want to point out, because it's only a couple of weeks away, that the next luncheon is actually quite soon. It's June 8th, right around the corner. And it will be featuring Dr. Shailene Joban from the university. She's an associate professor at the University of Alberta in the Faculty of Native Studies. And although the title is Indigenous Peoples and an Alberta primer, it will be of interest for anyone that is dialing in from outside the province as well. It's got a lot of historical context, and she will be speaking about, in part, about the importance of land acknowledgements and how to make them meaningful. So I commend this speaker to you. I've had a lovely conversation with her already, and I'm sure it'll be an excellent presentation. We are, of course, always looking for new topics. This is the second last luncheon presentation of this season. We will resume again in September, and we have a great lineup started already for the fall series, but we always enjoy hearing from you. So please reach out to us, send an email to info@adralberta.com if you have a particular speaker that you've enjoyed listening to or that you think you would like to see shared with others. So always appreciate your inputs in that regard. Next slide. Again, my name is Paul Conway. I'm the Executive Director with the ADR Institute of Alberta. And we present these luncheons on a monthly basis with the Foundation of Administrative Justice. For those of you that are not familiar with ADRIA, it's the Professional Association for Mediators and Arbitrators and ADR Practitioners in the province of Alberta. And we are one of 7 regional affiliates that cover the entire country under the umbrella of the ADR Institute of Canada. So we offer training and access to national designations in the fields of ADR. So I commend our website to you. I do want to take a few minutes though and just talk about some upcoming events, because there's not much time left before we all hopefully start enjoying our 1 jab or 2 jab summer. So right around the corner, as I mentioned, there's another luncheon on June the 8th on Indigenous governance issues, which I commend to you. In July, we have 2 more upcoming 40-hour ADR communications courses. So for those of you that might be looking to complete your training for mediation or prepare for mediation training, or just looking for that extra 40 hours of training, please consider registering for the July course. I think those 2 courses are the ones with the most space. There's one that's going to be in person here in Edmonton, and there will one that's online. So for those of you that are dialing in from other provinces, access is available to you for those courses, and I commend them to you. They're excellent courses. We have one last learner session coming up on the 2nd of June, again, right around the corner. The topic for that, these are free, by the way, and they're offered at the beginning of each month. This will be the last one until the fall. And the topic that's being discussed on the 2nd of June is when to terminate a mediation. So you might find that interesting as well. Finally, I want to mention that on June the 10th at between 5 and 7 p.m., ADRIA will be hosting its 1-hour annual general meeting. But you'll notice I just said between 5 and 7 p.m. That's because we're also bringing a full hour of improv comedy to you for your entertainment value from Rapid Fire Theater here in Edmonton. Last year, you might recall, we had the Chief Justice Queen's Bench provide our opening remarks. We're 15 months into this pandemic, and we just decided that maybe something a little lighter was required this year. So please consider joining us for between 5 and 7 p.m. It will include a full hour, both at the beginning and 45 minutes at the end, of improv theater with Rapid Fire. So you can register for that event online, and there will be more emails coming out forthcoming about our June 10th AGM. So thank you for allowing me to expand upon on those particular items. ADRIA has just launched a new website. It is experiencing, as all new websites do, a few technical challenges. But if you're not getting our emails, please make sure that your filters are set so that you're accepting emails from membership@adralberta.com or website at adralberta.com, and take a few minutes to take a look at the new website. We're working a few bugs out, but I think it's a really terrific looking program. On that note, I'm going to turn it over to Karen to add a few words about the FOAJ.
Thank you, Paul. I'm going to look forward to attending your AGM. I think that sounds like a very fun night, and hearing about what ADRIA has been accomplishing over the last year. Again, my name is Karen Popoff. I'm one of the executive directors at the foundation. I share this role with Sherilyn Dennis. Much like the ADRIA, the foundation is an organization dedicated to education and training of the administrative justice community. We have a number of courses coming up, presenting cases. This course allows for participants to prepare an effective hearing before decision-making. They'll take away different things like tips, practice guides, and forms. Next course coming up, June 21st, 22nd, 24th, and 25th, is case management practices. Just helps individuals who are dealing with heavy caseloads and to reduce hearing time, and also with difficult clients and just meeting some of those challenges that people just run into when they're having a lot of cases that they need to manage. And our last course is actually cultural competencies. It's actually, we've just increased that course to a 2-day course. So it includes a lot of things that are topical with the things that we are dealing with in this world, with examining cultural differences on cultural communications, judging witnesses, assessing evidence, conducting fair proceedings, and it goes on and on. So it'll just help dealing with some of the diversity issues that we all deal with on a daily basis. So I invite you to look at our website at www.foaj.ca. You also notice that we have a AGM coming up as well with our CTAJ graduation ceremony on June 24th. Thank you, and I hope you enjoy today's presentation. Back to you, Paul.
Thanks, Karen. Always great to hear what's going on with the FOAJ. And for those that aren't aware, the FOAJ offers training across the country. We work with the ADRIA Institute of Canada, of course, to do something similar, but the FOAJ is truly a national treasure, and we appreciate all the terrific learnings that you provide. Before we introduce Andrew, I'd just like to take a moment, of course. Today we're meeting virtually and from many different parts of the country. But as individuals, we participate on lands that were previously occupied by our Indigenous people. So we strive to remember their heritage and history, as well as the important contributions of many races and cultures in our shared history of settlement and immigration in Canada. Let us begin, though, by acknowledging that for thousands of years, the Indigenous peoples have walked these territories, weaving their identity and spirituality intimately with the land. We acknowledge with respect that we live, work, and play on lands often delineated by treaty or otherwise occupied by settlers. Keep us mindful of the many covenants and treaties that we have made and often broken with our Indigenous peoples. Knowing that they have suffered, may we find new ways to live with respect on this land, moving into reconciliation as we journey forward together. And it's now my pleasure to introduce Andrew Pillier from Thompson Rivers University in Kamloops, BC. He's joining us today, and he's also the director of the National Self-Represented Litigants Project West, which is the first partnership between the national project and another university. But Andrew is a teacher and a researcher at the university, and his work focuses on access to justice. I hope you've taken the time to take a look at his biography on the ADRIA website. He has certainly practiced in litigation with a national law firm, and he has clerked at the BC Supreme Court He's a founder of the Access to Justice Research Network, and he is an ardent supporter of the Self-Represented Litigants Project. So without further ado, I'd like to turn it over to Andrew, and he will be screen sharing. And this will be recorded. So if you're not able to catch the whole presentation, or if you know of someone that would benefit from it, you can access that recording within a week or so off the ADRIA website. Andrew, it's a great pleasure to welcome you to the virtual podium, and we look forward to everything you have to tell us. It's been a very interesting topic that's generated a lot of interest, and we have well over 100 people online today. So over to you.
Thanks, Paul, for the kind introduction. And I also want to thank both ADRIA and FOAJ for the opportunity to come talk with you today. It's the end of a busy term for me, but after a year like no other, it's nice to be able to share some of this information with you today. And the topic of my presentation is SRLs and ADR beyond the acronyms, and we'll get to that in just a sec. I'm putting up a couple of pictures of where I live, which is Kamloops, British Columbia. And I just want to take my own moment and acknowledge that where I live and where I work and at Thompson Rivers University is on the traditional lands of Tecumseh to Secwepemc within Secwepemc-Ulu, the traditional and unceded territory of the Secwepemc people. And it is a privilege to be able to live and work here. And I want to express my appreciation for that. I also want to express my thanks off the top to NSRLP, the National Self-Represented Litigants Project, which is located at the University of Windsor. As Paul mentioned, I'm the director of NSRLP West. And that is the first affiliation with NSRLP outside of Windsor. But much of the information about self-represented litigants, much of the data that I'll be talking about today, it was generated from research by NSRLP. NSRLP West has been up and running for almost 2 years now, but given the last year and a half, our research has been a little bit interrupted compared to where we hoped it would be. I also want to express my thanks to the Law Foundation of British Columbia, which has provided generous funding for NSRLP West. And let me just say briefly, the idea behind NSRLP West is to take some of the good work that's taken place in Windsor at the National Self-Represented Litigants Project and to expand that further across the country and to be able to focus on the experience of self-represented litigants in Western Canada, starting where I am in Kamloops and branching, growing out of there to include British Columbia, Alberta, parts of the Yukon, Northwest Territories, and perhaps also into Manitoba and Saskatchewan. So with this talk, here's what I propose to do. I'm going to talk a little bit about getting past these acronyms of SRLs and ADR. I'll talk then a little bit about some of the research and what we know about the SRL phenomenon. Then I'll take us back and I'll look at some of the codes of conduct that may apply to the work that you do. And I'll work through a couple of points there that seem to be particularly relevant to working with self-represented litigants and self-represented folks. I'll briefly talk about some of the case law emerging from the courts about things like duties to SRLs and how to try and strike a balance between fairness to the parties before you, while also recognizing that those parties may be differently situated. And I'll talk about some particular challenges. And by the way, I welcome comments and questions at any point throughout today. I'll do my best to keep up with them. And then I'll talk about some good practices that may be helpful for you in your practices when dealing with situations where one or both parties may be self-represented. And let me also say this at the outset. Right, I'm offering this in a sense of humility and curiosity. The research into self-represented litigants and the phenomenon of self-representation is far from complete. So I hope that some of what I can offer here is useful for you, but it's helpful for me to hear from you about what your experiences have been and what may be useful and what may be useful questions that you'd like answered in the future, and that can help direct us in some of our research for the future. So as Paul mentioned, I have a background as a litigator. I'm a currently non-practicing lawyer. After a few years in practice, I went back to graduate school because my research interest is in access to justice and the phenomenon of access to justice in Canada. But I recall being in mediations with self-represented parties. I'll talk about some of that a bit later. One of the things, though, that you'll see as a sort of core to this presentation is remembering that generalizations can sometimes be barriers to actually connecting with the person who is in front of you. And whether you're a mediator, an arbitrator, or a tribunal member, that can pose problems. So let me start with a quote that I've heard a few times recently and is a bit of a touchstone for this presentation. I am human, nothing human can be alien to me. Or if you prefer the Latin, homo sum humani nihil a me alienum puto. I'm sorry to begin a presentation with Latin, but this is a quote from Terence, a Roman poet and playwright around 170 BC. And I offer this at the beginning as a touchstone, as a way of reflecting on the fact that everybody has their story, okay? And so sometimes when we fall back to these acronyms like SRLs and try to attribute things to a whole class of people who may be before you, first of all, we're doing that in a relative research vacuum. And that can also get in the way of understanding that this point, that everybody has their story, everybody had their pathway to becoming the self-represented person that you see before you. Now, of course, alternative dispute resolution includes processes that can help parties resolve and move past disputes. And within the constraints of mediation, arbitration, or tribunal processes, there are pressing questions about how far can or should ADR professionals go in adapting their processes to self-represented litigants who may be in front of them. As I mentioned, research on self-representation is far from complete. Okay, so what I mean by that is that although we have some information about rates of self-representation in some courts and tribunals, that information is far from complete across the country. And we also don't have a good sense of the extent of self-representation in the population generally. Okay, so we could argue about whether self-representation is increasing or decreasing, and I'd suggest that that is actually not a terribly helpful conversation for your purposes. And probably what you may be more interested in is when you have a self-represented person in front of you, what are some useful techniques that you can employ to lead to a better ADR process. And even though there are significant gaps in the research on SRLs generally and in courts, this is particularly pronounced when it comes to SRLs and alternative dispute resolution. There frankly just is not a whole lot of good research that moves past anecdata, that moves past anecdotal experiences with one or two SRLs. So given this research gap, this relative paucity of research on SRLs as a whole, this is why it's particularly important to always start with the person in front of you. Okay, and hopefully this is something that, of course, you incorporate into your practice, but I reiterate this before moving into some of what we do know, or some of what the research suggests about self-representation and self-represented litigants. So having said that we don't have a great overview of the population, right? What do we know about SRLs? Well, let me start with what we know about access to justice problems. This is a slightly different question. And this is one where we have slightly better data. Over the past 15 years or so, there has been a few high quality research studies across the country, as well as around the world, that suggests that in Canada, approximately 50% of adults will experience a justiciable problem over a 3-year period. And a justiciable problem describes a problem that has a legal component to it, whether or not the person realizes there is that legal component, and whether or not they do anything about that legal component. Okay, so this suggests if 50% of adults experience at least one justiciable problem over a 3-year period, access to justice problems, justiciable problems, are ubiquitous in the population. We also have good evidence from these studies that less than 20% of those who've experienced a justiciable problem will obtain legal services to help address those problems. Now, this doesn't necessarily mean that that other 80% gets an unsatisfactory result, okay? It can mean that people are able to self-help or are able to deal with their problems in acceptable ways. But we should be, I'd suggest, concerned that there is a real possibility that for those 80% who experience a justiciable problem and don't obtain legal services, that they may be making decisions in the dark. They may be making decisions or avoiding dealing with problems that can have a significant deleterious effect on their lives. We also have good research from Canada, but also from other jurisdictions, that although cost is a barrier and a significant barrier for obtaining legal services, obtaining other types of services, it's not the dominant barrier. And this may be surprising, but there are other reasons why folks tend to not avail themselves of legal services or other services that may be helpful for them. They can be things like not understanding that a problem has a legal aspect to it. Now, another topic that I'll introduce is the idea of what's called critogenic harm. This is harm caused by law. We have some evidence that worldwide, about 29% of people report having experienced physical or stress-related ill health because of justice problems. That's from the World Justice Project. And in Canada, we have some research to suggest that approximately 50% of those who are faced with a significant legal problem also suffered mental health issues as a result. That's from one of the studies that produced some of the research about the incidence rate of justiciable problems. So if what I've just talked about are access to justice problems, I want to take a moment and situate access to justice problems and self-representation. If we think about the types of problems that people may experience and how they relate to things like the legal system or formal systems to resolve disputes, you can imagine there will be people who experience justiciable problems, and they may exist outside the system. A small percentage of those, so that in that 20% range, may find their way to legal service providers. And then a probably similarly small number of folks will ultimately end up in front of a court, tribunal, or some sort of ADR process. So what I've talked about up front as access to justice problems, that research speaks to this area, the area of folks who are largely outside the system. When we think about self-represented litigants, very often we're looking at folks who are within the system, right? Who have had experience working their way through, sometimes experiences with legal service providers, and then experiences in front of courts, in front of tribunals, or in ADR settings. As I've mentioned, and not to belabor this, but we don't have gold standard population data about who is an SRL. Okay, this is a bit different from some of that access to justice data that I put up, where we have population representative studies. I can't tell you how many people across the population self-represent. And what information we have to infer either from reports and research where self-represented people have identified themselves to researchers, or where they've been identified in courts or tribunals, and those courts or tribunals publish that research. Although very often the threshold of how you define somebody as self-represented differs between tribunals, between courts. Nevertheless, we do have some empirical research that indicates a couple of things. One, of those who have participated in research, most SRLs are acting without counsel, not because they want to, but because the cost of legal services is too high, or has become too high. So this is a little bit different from what I said up front, that cost is not the dominant barrier for most access to justice problems. When we're looking at the self-represented litigant population, research seems to suggest that cost is the major barrier, right? And recall that this is for folks who have already found their way into either the legal system or a system for dispute resolution. We also know that, again, of that population that's participated in research, many of those SRLs have had counsel, legal counsel at some point. And we also know that, again, regardless of what the exact level of self-representation is in a particular court at a particular time, the phenomenon of self-representation is ubiquitous. It is common and it is high. It is very likely that you will encounter self-represented litigants in court or in ADR processes. So to bolster some of this, I'm going to draw on some reported data from the BC Provincial Court for the 2019-2020 year. So in that period, the BC Provincial Court reported more than 103,000 appearances by self-represented litigants. And approximately 40% of SRLs appeared in family matters. In small claim matters, that level for that year was higher at about 66%. Now, it's worth noting that based on this data from the BC Provincial Court, SRL appearances had decreased from a high water mark of about 136,000 appearances about 5 years earlier. And just by way of reference, there were 107,469 new criminal, family, and civil matters in the BC Provincial Court during the same period. So let me unpack this just a little bit. 107 odd new matters means new filings, new cases starting. Appearances are tracking something slightly different, which is the number of times an SRL appears within one of those matters or a matter that's been existing for a previous year. But what I think this does suggest is, in addition to that data about family matters and small claim matter appearances, what I said in the previous slide about SRLs being ubiquitous appears to be backed up by this data, at least from the BC Provincial Court. And as I said, not all courts and tribunals report their data when it comes to self-represented litigants. This is one of the gaps in sort of uniformity of reporting across the country. So if we can use the BC Provincial Court as a proxy for likely experiences elsewhere, it's not ideal, but at present, that's some of the best information that we have, is just the self-reported information from courts and tribunals. So in part, this is a suggestion that tracking and reporting incidents of self-representation would be very useful. So those of you who are in a position to do so, I'd be happy to chat, or I'd encourage you to consider tracking and reporting information, incidence rates about self-representation. So just expanding on this data from the BC Provincial Court, you can see then the sort of 5-year trend of self-representation. You see that for each of these years, the majority of self-represented appearances happen in criminal matters, with second place being family matters and small claims matters. Recall, though, that as a percentage of overall of total cases, Small claims reports about 66%, SRLs appearing in at least about 66% of civil matters, small claims matters, and about 40% of family matters. So some of the other information that we have about self-represented litigants comes from the National Self-Represented Litigants Project. The project engaged in significant research in 2012, 2013 to solicit stories from self-represented litigants in courts across the country, and use that information to put together a pretty comprehensive, the best information that we have to date about who are self-represented litigants and what are their common experiences and what are some of the differences that we see. Since then, NSRLP has also had online intake forms, allowing anybody who's a self-represented litigant and who hears about NSRLP, either through social media or whatever, however they hear about it, to contact the project and fill out an intake form. And that intake form allows those SRLs to report some of the information about their experiences. So from the 2019 intake report, the project received 173 intake forms submitted in the 2018 to 2019 period. Now, it's worth noting again, this is not necessarily a representative sample, okay? 173 in the context of self-represented litigants across the country is a small number, and it's not necessarily representative. But of those who participated and filled out an intake report in the 2018-2019 period, 63% of those were over to the age of 50, with that age sloping off. So 21% in the 40 to 50 age range, 12% in the 30 to 40 age range, 3% in the 25 to 30 age range. And surprisingly, perhaps, no intake forms were submitted by individuals who are under 25 years old. Of those who filled out the intake forms, it appears that about 2/3 of those were plaintiffs and about 1/3 were defendants. And these numbers are consonant or consistent with some of the earlier reporting from NSRLP from the broader survey in 2012. 2019, about 90% reported that the other side was represented during their hearing or whatever matter they were working through. This may be higher than is true for the population as a whole. And certainly I would expect this to vary based on area of law that we're talking about, whether we're talking about family law versus civil matters. Of those who filled out the intake forms, about 40% identified as a person with a disability. Compare that with the rate of identified disability of 22% within the general adult population in Canada. Regarding education level, what we see is that the about 6% of SRLs reported having no high school, no high school diploma. 19% had obtained a high school diploma. 22% identified being college educated. Almost half, so 46%, had a university or professional qualification, and 16% indicated other. Regarding income of SRLs who participated and filled out the intake report, what we see here is that almost half, about 45%, reported an annual income level of under $30,000. And you can see that rate increasing and topping out at 9%, reporting an income of more than $100,000. So when we think back and we reflect on the finding that cost can be a significant barrier for SRLs and the significant reason why individuals are self-representation, we see that perhaps borne out in this self-reported data. It's worth noting, though, that again, there are gaps in terms of our understanding of even what the average cost of legal services are in Canada. Some of the best information comes from the Canadian lawyer reports, and even that has significant gaps and deficiencies. But you know, I'd suggest to you that even those in the above the under 30,000 level, the cost of obtaining legal services can be prohibitive for many of those individuals as well. So, sticking with the report, 68% of self-represented litigants had previously had a lawyer. 34% had used mediation, and of those who had used mediation, 10% settled in full, 15% settled in part, 75% did not settle. This is consistent with some information that also exists from the 2012 report, is that SRLs still often report that they did not understand the purpose of mediation or how to prepare for mediation. There's other information suggesting that SRLs often were not aware that mediation may have been available. And so this is something I'll come back to when I talk about some possible good practices to employ. But if we take a look at some of the codes of conduct and think about how these may relate to SRLs in particular, the ADR Institute of Canada's Code of Ethics has a few provisions that probably touch on some issues that are relevant to SRLs and your work as ADR professionals. So a member shall hold the integrity and fairness of the arbitration and mediation processes. A member should ensure that the parties involved in an arbitration or mediation are fairly informed and have an adequate understanding of the procedural aspects of the process and of their obligations to pay for services rendered. This is a significant one, I'd suggest. The information and what we hear from SRLs is that very often they are unaware, they are unclear about the procedural aspects of the process. And this may be true, I'd suggest, even if that information was offered to them at the beginning of a mediation or an arbitration. And so I'll come back to this, but there may be better ways of imparting information and also checking with parties to ensure, and especially self-represented parties, to ensure that they understand the nature of procedural information that they're being given. Another element of the Code of Ethics is that a member in communicating with the party shall avoid impropriety or the appearance of impropriety. So this perhaps raises concerns that ADR professionals may have about how should they communicate with SRLs to ensure that they are not engaging in impropriety, to ensure that they're not apparently favoring one side, the self-represented party, over another. I'll come back to this. A member shall conduct all proceedings fairly and diligently, exhibiting independence and impartiality. A member shall be faithful to the relationship of trust and confidentiality inherent in the office of arbitrator or mediator. And a member shall conduct all proceedings related to the resolution of a dispute in accordance with applicable law. And on this last point, I'm going to, in a couple of slides, come to some recent statements from Canadian courts around courts' responsibilities and duties regarding self-represented litigants. And so I offer that to you as another piece of the puzzle that you can use to ensure that you are conducting proceedings in accordance with applicable law. Let's look at the ADR Institute of Canada's Code of Conduct for Mediators just for a sec. So among the principles there, the principle of self-determination, the idea that parties have the right to make voluntary and non-coerced decisions during mediation, that the mediator is to provide information about the mediator's role, similar to the comments I made on the last slide. There may be scope to ensure that that information is imparted not just in a formal way, but that it is substantively understood by SRLs. And if it's not substantively understood, I think that would be a pretty challenging situation for mediation to take place in. The mediator may not provide legal or professional advice, and this can be a challenging area. Certainly in the US, there's been discussion and debate over a number of years about mediators' rights and responsibilities, especially concerning self-represented litigants, and whether mediators, what the line is that they shouldn't go past in describing the process and trying to assist SRLs to be effective participants in mediation. The code also includes the provision that the mediator shall advise unrepresented parties to obtain independent legal advice. And I'll come back to this because we've heard from self-represented litigants, certainly in the court setting, that the repetition of the advice to go and seek independent legal advice can become almost dispiriting after a point, especially for SRLs who are self-representing not by choice, but because of financial reasons. And so I'll suggest some ways that advising unrepresented parties about obtaining independent legal advice can be done in ways that may be better received by many SRLs. Another principle in the code is that of independence and impartiality, so that mediators should not act as advocates unless the parties agree otherwise after full disclosure. Regarding the quality of the process, that the mediator make reasonable efforts to ensure that parties understand the mediation process, and that the mediator should conduct mediation to permit parties to participate effectively and to encourage respect among the parties. So all of these, I suggest, come back to thinking about how to design your processes in ways that allow SRLs to take on information in ways that respond to their particular journey through whatever dispute they've been going through. For those of you who are lawyers, I'm going to pull out the Law Society of Alberta's Code of Conduct just to briefly speak about the ethical requirements, positive requirements on lawyers when it comes to dealing with SRLs. So in Alberta, when a lawyer deals on a client's behalf with an unrepresented person, the lawyer must advise the unrepresented person to obtain independent legal representation, must take care to see that the unrepresented person is not proceeding under the impression that his or her interests will be protected by the lawyer, and make it clear to the unrepresented person that the lawyer is acting exclusively in the interests of the client. Now I see there's a question in the Q&A, so let me just go there. And the question is, perhaps I missed this earlier, do SRLs who act on their own behalf in regulatory practice review hearings also have access to provide feedback toward the research that I mentioned earlier, or is that only for SRLs who are involved in court-ordered mediation or court proceedings? So no, the intake process through the NSRLP can include folks who've been in front of tribunals, I think, if I understand the question properly. So the challenge in doing this research is reaching folks who've had the experience of being a self-represented litigant, and that is defined fairly broadly, but certainly includes administrative tribunal experiences. So I don't have at my fingertips the proportion of feedback that we get from those who've been through tribunal processes exclusively versus those who've been in court. But that is something that that we ask about, and I should say also that the intake form is evolving. So there was a point in time where, for example, we didn't collect demographic information, ethnographic information about the people who are reporting, and we're trying to increasingly do that. There is a mountain to climb when it comes to gathering and collecting robust data about access to justice generally, but that's certainly true about self-represented litigants. So the data that I've put before you so far is drawn from individuals who may have experienced either court but also tribunal situations. Paul, did you want to say something in response to that?
No, I'm good, Andrew. Please continue. You're doing a great
Okay.
job.
So just continuing with the Law Society of Alberta's Code of Conduct, the commentary under Rule 7.212 indicates that a lawyer has the same general duties of honesty, courtesy, and good faith that are owed to professional colleagues, and also that the lengths to which a lawyer must go in ensuring a party's understanding of these matters will depend on all relevant factors. Okay, so turning from these codes of conduct to look at case law, you may be familiar with sort of the leading case from the Supreme Court of Canada when it comes to self-represented litigants, and that's the Pintea and Johns case in 2017. It's a very short case at the Supreme Court level. And what it is most notable for at that level is the SCC's endorsement of the Canadian Judicial Council's Statement of Principles on Self-Represented Litigants and Accused Persons from 2006. This is an oldie, but a goodie, and something that courts are increasingly referring to. So it's worth going back and unpacking some of what's in the Statement of Principles, and I'll do that over a couple of slides. The statements from the Canadian Judicial Council fall into three areas. One, promoting rights of access, promoting equal justice, and the responsibilities of the participants in the justice system. So each of these statements is followed by some principles and commentaries. I'm not going to go through these exhaustively, but I think it is helpful to hit some highlights about what the Supreme Court of Canada has endorsed when it comes to what judges should be doing and other participants in a court system should be doing regarding self-represented litigants, because that has, I'd suggest, significant value to those of you who are dealing either in tribunal settings, but also in ADR settings. And of course, you can tailor these to your particular circumstances, but let's go through these for a few moments. So under the first of these principles, promoting rights of access, the CJC explained this principle in this way: judges, the courts, and other participants in the justice system have a responsibility to promote opportunities for all persons to understand and meaningfully present their case regardless of representation. So again, this comes back to the point that I made about the responsibility to promote and ensure not just a formal understanding of process, but something deeper than that, that somebody has some substantive understanding of the process and an opportunity to present their case. Now, under this point of promoting rights of access, the CJC statement goes into 4 principles, and there are 5 commentaries on that. Some of the principles include that all aspects of the court process should be open, transparent, clearly defined, simple, convenient, and accommodating as much as possible. One of the challenges in trying to interpret and implement these principles is that these seem like all good things, and they are more challenging to do in practice than they are to enunciate. So obviously, as much as possible is a limiting factor on each of these items of desideratum. So, to what extent should a court process be open, transparent, clearly defined, simple, convenient, accommodating? Well, there's the rub in practice. But what I hope to do when I talk about some good practices is suggest some ways of bringing these principles in ways that can be scalable and can respond to the specific person in front of you, the specific SRL in front of you. Another aspect of this promoting rights of access principle is that court processes should be supplemented by processes that enhance accessibility, informality, timeliness of resolution, including ADR. So there is this exhortation to courts to ensure that SRLs are aware of and able to make use of ADR processes. Also, that information, assistance, and self-help support should be made available for SRLs. This is pitched at a level of generality that can be difficult to quibble with, but again, I'd suggest that the challenge here is ensuring that that information, assistance, and self-help support is something that the SRL is actually aware of and is actually functionally able to use. Also, judges and others should inform SRLs of the consequences and responsibilities of proceeding without a lawyer. The statement suggests that judges and others should refer SRLs to legal aid, pro bono, and other representation services, and should refer SRLs to information, education, and other assistance. Again, I'd suggest this is a double-edged sword in some way. Well, making SRLs aware of other services and referring to other services can certainly be very helpful. There is also the challenge that if that SRL is there because they can't afford legal services, and I think this is true in many parts of the country, but if legal assistance, if legal aid and other sources of legal information are significantly diminished from where they've been years or decades ago, this can be an added frustration for the SRL to just be told again that you should make use of assistance when that assistance is often not available or very difficult to find. I'm going to just look at the Q&A for a second. I see, is there a basic concept and representation based on natural justice that is presented in good faith and integrity based on custom, tradition, or industry standards? So I'm not entirely sure I understand the question, and with apologies, I maybe should have said this up front. I teach civil procedure, family law, and some other things, but I have not been teaching administrative law in a little while. So it's I'm perhaps not as up on the content of natural justice as it's been most recently enunciated. If it's okay, I'll try and come back to this question and think about it. And if you can help me so I don't flounder through your question, I'd appreciate that. Apologies. Let me try and get through the rest of the principles from the CJC statement. And one of those is promoting equal justice. So the principle itself is that judges, the courts, and other participants in the justice system have a responsibility to promote access to the justice system for all persons on an equal basis, regardless of representation. And here again, there are 4 principles and 4 commentaries. Those principles include that judges should do whatever is possible to prevent an unfair disadvantage to SRLs, that SRLs should not be denied relief on the basis of a minor or easily rectified deficiency, that judges should engage in case management to protect the rights and interests of SRLs, and that this should begin as early as possible. And finally, that engaged case management may be needed. This can include explaining the process, inquiring about whether parties understand the process, making referrals to outside agencies, providing information about the law, modifying the order of taking evidence, and questioning witnesses. So again, here in the CJC's principles, we have some description, some elaboration about where this line is, about where judges and decision makers can go. Engage case management is okay. It's encouraged. And this includes not just explaining the process, but also inquiring about whether parties understand that process, right? So this, I think, gives a more robust idea of what your responsibilities can include when it comes to explaining process and checking in to make sure that SRLs understand that process. And in doing that in a way that does not amount to a procedural disadvantage to another party. The third and final of the principles in the CJC statement is that the responsibility describes the responsibilities of the participants in the justice system. And the statement here is that all participants are accountable for understanding and fulfilling their roles in achieving the goals of equal access to justice, including procedural fairness. This principle is elaborated in significantly more detail than the other two. Here there are 23 principles that are broken into 6 categories, 6 groups by justice system participant, including principles for judges, principles for system administrators, systems for SRLs, and so on. And then there are 6 commentaries related to these. So I won't pull all of them out, but just to highlight some of them. Some of the principles include that judges should meet the needs of SRLs for information, referral, simplicity, and assistance. But judges have no obligation to assist SRLs who are disrespectful, frivolous, unreasonable, vexatious, abusive, or making no reasonable effort to prepare their case. SRLs are expected to familiarize themselves with relevant legal practices and procedures and are expected to prepare their own case. SRLs are also required to be respectful of court processes and officials. So let me take a moment and just come back. And just to pick up on another question, does proof need reference to legal terms and precedent? So I think this is a hard one to answer in the abstract, but as I understand the question, you know, what I've tried to do here is put up the statements from the Canadian Judicial Council that have been endorsed by the Supreme Court of Canada, and that suggests that in judicial settings, judges are allowed to do things, for example, going back to one of the principles, to modify things like the order in which evidence is presented in order to allow an effective self-representation by a self-represented litigant. Self-represented litigants are still required to prepare their case, but courts are allowed and indeed encouraged to take steps to ensure that SRLs understand the process, and courts can take some steps to modify the process to allow SRLs to effectively engage in that process. And so what I'd suggest is that if that's true for settings in court, right? In ADR settings, that's something that you probably have increased latitude to vary, especially if you can do that early on in designing the ADR process. And if you can do that with the consent of the parties to the mediation or the arbitration up front. Now I see I'm going to flip over to the chat, and I apologize that I have not had my eye on the chat as much as possible. So I'm just going to very briefly try and catch up on some of the most recent points.
There's a couple of points there, Andrew, about
Sure.
Just legal aid. You know, legal aid is a provincial responsibility, of course, but there's been at least 1 or 2 suggestions that, you know, more legal aid or enhanced legal aid might be a bit of a resolution.
And that's true. I mean, one thing I can mention is that in Canada, the high watermark in terms of funding for legal aid was in the 1980s, and even though there have been some increases in recent years in legal aid funding in some provinces and territories, that is still relatively small compared to the drop in overall legal aid funding that's taken place before then. Also, legal aid tends to be funneled primarily towards criminal matters rather than civil or family matters. And so that can create a hardship. There are complex reasons for that, including the fact that legal aid is effectively constitutionalized for many criminal matters, but not so for certainly civil matters. For some family matters, it is. And I'd also take you back to one other point, which is that, increasing funding from legal aid is certainly seems like an important step in trying to address access to justice problems. But recall that cost is not the dominant barrier for all access to justice problems. So in addition to legal aid funding, other things like being aware of the existence of legal solutions is part of that problem. I see a question here. What does Andrew think about the participation of Mackenzie Friends in the process and access to justice? And what if Mackenzie Friends were trained and part of a legislative body? That's a great question. And if I can, I'll come back to that in just a couple of moments when I go to some good practices. And then I also see a question about dealing with unreasonable SRLs. And again, that's something that I'll come to in about 2 slides, if that's okay. Okay, so since the Pintea decision, courts have dealt with that decision. They have interpreted and applied the statement of principles from the CJC. And the NSRLP has done a review of the cases across the country that have mentioned Pintea, have applied the principles since 2017. And while courts very often do a good job of bringing these principles into practice and applying them, there also appear to be some questionable limitations that courts seem to have read in to the statements of principles that don't actually appear in the principles. So I'll point these out. They include some courts holding that judicial assistance may be forfeit for previous bad behavior by a self-represented litigant, that judicial assistance may be withheld from so-called sophisticated self-represented litigants. There's no clear test about what a sophisticated SRL is, but in some cases, courts have suggested that where an SRL is either educated, highly educated, or has experience with formal legal processes before, that they may require less judicial assistance. On this point, I'd note that although we have some information about the education levels of SRLs, or at least those who identify themselves to NSRLP West, there is very often a significant difference between levels of educational attainment in somebody's life and their understanding of the legal system, or whatever system we're talking about, whether we're talking about an ADR system. So I caution that this identification of sophisticated SRLs can be an overbroad and I'd suggest misleading identifier. Certainly you may have somebody in front of you who is well versed with the process, and in that case, you probably, once you've determined that this person understands the process that you're about to engage in, you don't need to go exhaustively through things that you might for an SRL who is less aware of the process. But again, I come back to the point that you need to tailor your process to the individual in front of you, and to avoid being led to generalizations about SRLs that aren't borne out by good evidence. Some courts have decided that the CJC principles do not confer so-called special status on SRLs. And courts have also read in that there is no duty on opposing counsel to assist SRLs. Now, each of these apparent trends in some of the case law is troubling and is problematic because they don't actually reflect what's in the statements of principle. And so I would encourage you, if you're looking for direction and assistance, your first port of call should be the statements of principle from the CJC. Okay, let me come to some challenges that are associated with dealing with a case, a matter, a process where there's at least one SRL. As with any case, any situation, ensuring safety for all parties should be of significant importance. This could be true if you're dealing with a party in a perhaps family mediation where there may be a history of domestic violence, and ensuring that there is safety for all parties to engage in that process. But in those in situations where parties are represented, you might be able to rely to some degree on counsel to have done something like a family violence screening up front. That's not to suggest that you wouldn't necessarily want to satisfy yourself of that. But when there's not counsel present, ensuring safety for all parties falls more clearly on you as a mediator, as an adjudicator, perhaps as a tribunal member. And so that's something to bear in mind. If parties are in a process and they feel safe and they feel unsafe, either because of the presence of the other party or because of their fear of the process and their lack of understanding of the process, that can put you in a terrible position for a successful ADR process to follow. Certainly a challenge for decision makers and perhaps for mediators as well is understanding what fairness requires, particularly when there is a clear imbalance in terms of procedural understanding among the parties. If one party is represented, another party is unrepresented, or if you had two self-represented parties who have different characteristics, one of whom suggests that they may be quite well versed in the process and the other whom is not. How do you try and tailor what you do to respond to these different positions of the different parties? And certainly there can be different challenges if one party is represented compared to situations where both parties are. Some potential disadvantages that SRLs may experience, it's helpful to think about this in some detail when we're talking about SRLs and what types of disadvantages they may face. These could include a lack of substantive legal knowledge about whatever the dispute is about. They could also be a lack of knowledge about the process itself, okay? And based on the CJC principles, it appears certainly much clearer that you can go much further in explaining the process and ensuring that parties understand the process without worry of wading into giving legal advice and sort of supplementing parties' substantive legal knowledge. There may also be inexperience or lack of procedural skill. So in addition to knowing what the process is, there are certainly skills that are involved in being an effective party to a mediation or an effective advocate. And so this inexperience or lack of procedural skill can be another hurdle that SRLs faced. And finally, and this responds, I think, or picks up on one of the questions, how should you respond and what should you do about bad actors? And also, how do you know who is a bad actor, who is abusing the system, abusing the process as an SRL? So I'm just going back to the questions to see if there are any others here. And I see one, do you think that the CJC principles are also applicable to processes where parties may be underrepresented? For example, where they're represented by a non-lawyer agent. So it's a great question. I think, again, the venue, the forum is going to affect the answer to that question. So if we're talking about a court setting, right, that gets into something like Mackenzie Friends, or if somebody if an agent has been given leave to appear in court, versus perhaps a tribunal setting versus, for example, an ADR or mediation setting. And to give a broad answer, yes, I think the CJC principles are applicable, although, again, you're going to want to tailor those to the specific circumstances. So what I'm thinking of here is that, depending on the venue, you're going to be interested to ensure that parties are able to effectively bring forward their own positions, to understand the process they're going through, and to be able to engage effectively. The CJC principles, I think, are helpful in thinking about that, but they don't necessarily give a lot of tools about how to do so. So if parties are So I'll speak to some of this in these next two slides about good practices, and perhaps you can let me know if these address your question. So some good practices to think about. Okay, I've said this throughout this presentation, but focus on the people, the person engaged in trying to resolve the dispute. I think this is probably something that should be pretty applicable for any process, whether we're talking about mediation or other kinds of adjudication, or even in courts themselves, right? There is something special about the fact that the entire sort of legal process, and certainly the ADR process, involves treating people not based on their broad population characteristics, but rather on the specific circumstances of the matter that you're hearing and the circumstances of the parties within the context of that matter. And so what I'd encourage you to do is actively inquire about the parties and their circumstances, particularly where you see self-represented litigants. Provide information about the process in advance, and if possible, well in advance of the process. So that is not on the day of the process. Although ADR systems can be less intimidating or less formal than court processes, they may be perceived as no less intimidating for an SRL, particularly an SRL who has had negative experiences with other forms of dispute resolution or with the legal system more generally. And so as part of providing information about the process in advance, ensure that the parties understand that information that you provided. There may be latent issues about anything from ability to read or ability to understand the process. Parties may have non-visible disabilities that they don't want to admit to for fear of flagging those to the other party, especially if it's in an adversarial setting, but that may impede their ability to understand information that you assume they should understand. So a way of ensuring that the parties have understood that information and that they can inform you about that, preferably in a way that doesn't require them to divulge their circumstances to the other party to the process, can be helpful. And as I've said, remember that even when an ADR process is less formal than court, it may not be less intimidating for a self-represented litigant. For them, the prospect that this is going to resolve the dispute, right, can have significant consequences, can be a significant stressor in and of itself. Recall earlier in the presentation when I talked about critogenic harm, the idea that the process, the legal process itself, can do harm to the parties to it. I'd encourage you to consider employing a trauma-informed process, and that can mean some different things, but consider ensuring that you have processes in place to ensure the physical and emotional safety of the participants. In mediation, this is something that I'm sure you're well aware of, ensuring that parties are not, for example, in the same room or even part of a process where physical or emotional safety may be a challenge. But I'd encourage you to consider this and to keep this in your mind in any situation where you're dealing with at least one self-represented party. Design the processes that you try to employ to ensure choice and, where possible, control for each of those parties and for self-represented parties among those. These can be, I'll mention just one small thing, but these can be small things such as not including a default that only counsel needs to sign off on something, ensuring that parties ensure that they have some of the same degrees of control over the process that represented parties do. The signaling around this can be important. Where possible, engage in collaborate in decision-making. ensure transparency, clarity, respect, and personal boundaries. Some of this recalls the language from the CJC's Statement of Principles. Where possible, prioritize empowerment and skill building. So again, in thinking about the educational component of ADR and providing information to the parties about the process in advance, that could also include, for example, having referrals to skill building opportunities that are available in your community when it comes to things like advocacy or how to effectively engage in mediation, and developing tools for parties, for SRLs, to gain some of those skills can be important. All of this means that you may spend more preparatory time with an SRL. And I think it can be important to acknowledge this up front. This does not mean that you're treating parties unfairly or unequally. If we think about the concept of substantive equality, what that means is that recognizing that everybody has their story, everybody comes in with different background, a different history, that doesn't mean that everybody gets to the same starting point in the same way. And so you may need to provide more information, more preparatory time for an SRL than you would to a represented party who is a repeat player. Now, this may be a frustration for the repeat party who is represented, who wants efficiency out of the process above all else. But in terms of thinking about the importance of fairness in the process you're engaged in, recognizing that you may spend time unequally in preparation between different parties can be important to acknowledge this, and to acknowledge this to all parties up front. And I mentioned this before, but if you're recommending legal assistance to an SRL, this may in itself be a source of frustration for that SRL. And so ways around this can include being familiar with unbundled legal service providers in your community. In British Columbia, for example, there is a portal online where lawyers who provide limited scope retainers, and basically what that means is that rather than taking on a client for the entire case, they may agree to just, for example, help them prepare a mediation brief or help them prepare for mediation. You may be able to find out who in your community or in the community where the SRL is located, who provides these services. So rather than telling an SRL that you have to go and hire a lawyer carte blanche for however many hundreds of dollars an hour, you can say, look, you can have somebody help you prepare for this mediation, and you can set the amount of time that they put into it. You may be able to set the cost of that, and you have some cost certainty in doing so. Legal coaching is another concept you may be familiar with, where parties hire a lawyer not to prepare materials for them and to represent them, but to coach them in how to self-represent. And that can decrease the costs for the SRL and allow them to gain experience, gain skills that they wouldn't otherwise have. It's also a good idea to be aware of pro bono and so-called low bono services that may be available in your community. So low bono services describe situations where lawyers provide legal services at a lower rate, at a rate that is sort of on a pay what you can type of level. So discussing these with an SRL well in advance, or when you're recommending that they obtain legal assistance, can make it more approachable for them than simply telling them you should consider having a lawyer. And next, I'm going to suggest that you might consider a responsive regulation approach to encouraging good behavior and discouraging bad behavior. And this idea builds on the work of Ian Ayers and John Braithwaite, and I'll describe that in the next slide, but let me take a moment and just look at the questions on here. I see a question, what service in BC am I referring to? Apologies. A moment ago, I spoke about unbundling and whether you can find a lawyer in your community who provides unbundled legal services. In BC, if you Google unbundling BC, you can find a map, a list of lawyers. This isn't a complete list, but lawyers who have identified that they are willing to take limited scope retainers, and that can give you at least some names in particular communities, or SRLs can look to where they live and they can see lawyers who have said, I'm willing to talk to somebody about a limited scope retainer. So I'll see if I can put that in chat before we're finished. And thank you for the comment that I see that no person or process can ensure safety. We can strive to maximize safety. That's right. And I didn't, if I said otherwise, that was a misstatement. But what I wanted to try and ensure is that as mediators, as ADR professionals, as tribunal members, that you're thinking about and engaging in process design in a way that tries to maximize safety for the parties who will be engaging in that process, and that you are inquiring of those parties to ensure that to the extent possible, you can maximize safety in those circumstances. So let me spend just a moment talking about responsive regulation. This is and how it can apply to SRLs. This is a visual that's taken from the South Australian EPA and is featured on John Braithwaite's website regarding responsive regulation. If you're familiar with responsive regulation, you may have seen this in a pyramid form in the past, but basically this is a way of dealing with, in a regulatory context, how to increase the magnitude of carrots or sticks for individual parties or individual regulatees to try and make them compliant with regulations. So in the context of environmental protection, this can include things like taking, let's say, a business that you're regulating, and if they are behaving badly, if they're doing things that are not in compliance with regulations, well, first you take steps to try and educate them to ensure that they have access to the regulations and they understand those regulations. If they continue to act in ways that are non-compliant, then you steadily increase the scope of enforcement and the scope of sort of negative outcomes, negative tools that you might use, leading to, in this case, criminal prosecution for a environmental regulation violation, if that's appropriate. On the other hand, when you have parties behaving well, right, you take steps to give them more resources to enable them to act even better. And so if a regulatee, if a business is confused about how to be more compliant with environmental regulation, you might consider enabling that better behavior by providing them more resources, more education about how to get over hurdles they may be experiencing. As they become even more compliant, you may recognize that and give praise. Now, this is a bit of I'm describing this in a little bit of a simplistic way, but I suggest that this is something that may be helpful for those of you who are dealing with SRLs to think about as a way of tailoring your response to the individual in front of you, and to increasingly, so you start sort of at neutral, you inquire about the individual, and then you build either carrots or sticks to respond to the types of behavior that you see in the process based on that individual litigant, that individual person. And this all speaks to the importance of inquiring, of listening, and of responding appropriately to try and build trust between the party and you as the mediator, as arbitrator, or as tribunal member. To give you an idea of why this is important, I'm going to draw out two quotes from the NSRLP intake report from 2019. From one SRL, I'm treated as though being self-represented is inherently an abusive process. I've not had trouble with legal arguments. I've had problems with process and procedures which are either obscure or informal, which has left me at a disadvantage, right? And recognize that informality, the idea that we assume that people understand these things because this is how they go. But for parties who've never been through the process before, this informal or unspoken part of the process can leave SRLs at a real disadvantage. Another SRL described the process as extremely draining emotionally, Kafkaesque tasks, not heard, bullied, definitely need more hands-on assistance to not feel so alone. And so all of this, I think, should resonate in these times we find ourselves in, and takes me back to the quote from Terence, this idea that all human experience should not be foreign to us, that we should understand the position of somebody else, and we should try and build our empathy towards them. And finally, I leave you with this, that amidst all this, kindness can go a long way. So thank you for your time. I put a link here. My slides will be shared, I understand, after this, and you have a link here for the NSRLP website. And I'm happy to take questions for those who are able to stick around. And I'm going to briefly try and find the link for unbundling BC.
Kindness is a great place to end, Andrew. And I got to give you full credit. I know we chatted, a week or two ago, but you have done an excellent job of anticipating any questions that I might have had anyway, and certainly many of those that have been posted on the chat function. For those of you that are online, and there are well over 100 of you, please type in any questions you have into the chat function. We'll do our best. Andrew will scroll through them as well. I think one of the great takeaways for me, Andrew, was the CJC guidance to judges, which I think is so incredibly relevant to arbitrators, tribunal chairs, tribunal members, and even to mediators. Your presentation on those points and even some of the best practices touched on, what do you do with frivolous and vexatious? What do you do with sophisticated versus unsophisticated? And your emphasis on safety was greatly appreciated. I think that's very important, particularly for our members that work with separation and divorce, because emotions tend to run a little bit high in those settings. You even covered the frustration that the represented party might feel in a process where the unrepresented party seems to be getting a lot of airtime in front of the tribunal chair. And I can speak from personal experience. I was in Nova Scotia as an employer at the WCB Appeals Tribunal, and I think this speaks to what you talked about, educating and taking that extra time, slowing down the process. Because I remember feeling really upset and nervous about all these new allegations that were emerging from the self-represented litigant side that we had not heard before and certainly had not time to prepare. And I was certainly well represented, with staff and legal assistance. But I came to learn, and for me, this was a learning after the fact, that a tribunal chair in this particular case will give this extra latitude, this extra time to make sure that the self-represented litigant feels heard. It doesn't necessarily add weight to these, any spurious allegations that might be coming forward or new information that wasn't brought forward properly in the process. But for me, the real takeaway was the need to slow the process down and make sure that even the represented side understands that this might happen. And I'll invite you to comment a little bit more on that. And then I have another question about the interface between mediation and the law. And any advice that you have, returning to the premise of this question, any advice you have for, arbitrators and tribunal chairs who cannot necessarily spend caucusing time with one party, and then the other, because it does have to be done in sort of a plenary fashion, which can be frustrated or alarming for the represented side.
Well, and so there's a lot in there. And Paul, I'm also going to try and pick up on some of the questions I see and comments I see coming up
for sure
on the side.
I know you want to talk about the Mackenzie Friends as well.
I was going to come back to that, and I will, but
sure you will.
I also see some questions coming up around connections between self-represented litigants and mental health issues. And I don't have any specific research on this. Again, I come back to the point that there is a lot. The reason why NSRLP and NSRLP West exist is in large part to try and fill the gap in the research that we have about the phenomenon of folks self-representing. We know, though, that there is a significant mental health issues in our society broadly. And so there is all sorts of reason to assume that you will see at least similar levels of mental health issues among self-represented litigants. And recall what I said about critogenic harm, right? Some people will experience dispute resolution or legal processes as a potential trauma and may respond in kind. So, in thinking about how to listen to how to engage SRLs in a process and how to design those processes, especially if you can't caucus with them, maybe there's an opportunity to engage in intake processes that can elicit some kinds of information. And I think this connects to what I was just talking about, especially allowing participants to give information about their specific circumstances where they don't have to necessarily give that information to the other side. So if there's a way of providing information that will be held in confidence by the mediator or the arbitrator relating to the SRL's particular fears or background, that doesn't get passed over to the other side, if that could be done through some way of intake, that may be helpful. And again, doing that in advance of the process. I recognize that adding one more thing to your list of things to do is probably not something you want to do. But when you consider that establishing that level of trust and establishing comfort with the process can lead to a better outcome and can prevent a process from blowing up when you're in the midst of it, some of that preparatory work, I'd say, can be worth its weight in gold. Does that
Very
answer?
helpful. Yeah. Tom's question about Mackenzie Friends was new to me, and so I quickly Googled it. It looks very interesting. It's not a term we hear in Canada, I don't think, a lot, but maybe you could expand upon that a little bit. Certainly, we're familiar with it in mediation, this concept.
Right. So the Mackenzie Friend is an idea that originated from the courts in England in 1970. And originally, it was a party who took an Australian trained lawyer to court with them, but the Australian trained lawyer couldn't speak to the court in England. So what the lawyer did was basically sat at table with the party and helped give questions, helped give some advice to the otherwise self-represented person in court. And the case named Mackenzie Friends comes from the name of the case where the court said, yes, this is okay within certain boundaries. So in Canada, there are actually Mackenzie Friends, and Alberta and Ontario are two provinces where you'd see the term come up actually quite a bit. They've picked up on that UK jurisprudence, and you'll see courts referring to Mackenzie Friends. In BC, the more common term is support persons, but the idea behind this is that you can help to decrease somebody's stress and also supplement their process knowledge and their ability to act by allowing them to take somebody with them. Now, obviously, there may be concerns that you'll have in terms of designing your process to ensure that that support person is also bound by any confidentiality requirements that are part of the process, and so you can adapt your systems accordingly. And I see that we have a Mackenzie Friend as part of the group today, but there I think is real potential benefit to, again, perhaps proactively inquiring of parties whether they want somebody there to act with them as a support person. If we think about other systems, medical systems, for example, this is fairly common, right? The idea that having somebody else with you to participate in your health journey can decrease your levels of stress. Now, you may want to be thoughtful about the boundaries you'll set on this, the idea that perhaps a Mackenzie Friend is not there to act as an advocate, but is there to act as a support person. And so I think some clarity around what that role entails can be helpful. But certainly the idea that people don't have to go it alone and that they can have somebody that they trust there with them can go significant ways to alleviating some of the fear that people have of the process, particularly when they've been through legal processes where they've felt alone, they've felt atomized through much of that experience.
Having a support person is certainly a huge part of the mediation process, particularly when people don't want to be accompanied by their legal counsel, which is often encouraged. I just want to let the participants know that we will continue till at least 1:15, perhaps a few minutes beyond. We'll try to answer as many questions as we can. There has been a question, I suppose this is an extension of, vexatious, frivolous, even safety. But what do you do with an abusive participant? And also, what do you do? Another person asked the questions about what do you do about people who have unrealistic views on what the outcome might be? And I've certainly experienced this. I'm sure many have. They've watched too much American television, et cetera, et cetera.
I mean, great questions. I'm not sure I can give you easy answers to any of these, right? But off the top of my head, again, I think the role of ADR professional as educator is something that I think is important here. Something I'm aware of in part as a parent is that sometimes it's not what the content of what you hear is, it's who you hear it from. And so I don't, perhaps enlisting an evaluative mediator as part of your practice could be a way of doing that, and seeing if there's somebody else who can give an opinion during the course of mediation, for example, about whether something is realistic or not, being aware of concerns about providing legal advice or not. But framing that evaluative mediator up front could be one possibility. There can also be value here in unbundled legal services to do just this. And if it's possible to, if the matter is one of trying to frame an issue so that it's easier for somebody to go and ask for advice on this legal question, can you tell me what do you think is an answer to this? That could be that could be easier than just sending somebody off and telling them to get independent legal advice. So here, trying to do some of that work in terms of framing the issue that somebody has to get outside advice on can be helpful. I see a question here about, can I discuss a little about balancing power between SRLs and their respondents that go beyond process, so in terms of accountability, relationships, or safety? I'm not sure I have a good answer that I can offer on this one. I mean, obviously that could be a significant challenge, especially if parties have ongoing points of contact and there exist power imbalances. I'm not sure I have anything that comes to mind outside the process that you've engaged in, whether that's mediation or ADR. But let me think about that, and if I have anything that comes to mind, I'll try and offer that.
Sure. One of the questions that mediators often face, be they lawyers or non-lawyers, is, do I need to bring my legal counsel with me to the mediation? No. And a lot of our mediators would say, would certainly be recommending, it's in the code of conduct, if you will, that they should have access to legal advice, but they also will often suggest that you don't actually need to have your counsel with you. You might want to phone them, but you might want to check in with them. You certainly want to consult before you sign any sort of final mediation settlement. But it kind of brings us to the subject of semi-represented litigants, Andrew. If you're, if you have access to legal counsel, but you're representing yourself in a mediation, for example, and I know some of our mediators have encountered this. They go back, they come up with the draft terms, everything looks rosy, and they're advised to go and check with their lawyer before they sign in final, and their lawyer says, oh, no, you can't sign that, you need to do this. And I think self-represented litigants sometimes forget that the lawyer was not present for the mediation, did not hear what came out, and is there to advise you what has a fiduciary responsibility to advise you, but not to tell you what to do. And I'm not sure, who do we educate here? The self-represented litigant, or are we to represent, do we need to educate the lawyers in this regard?
So I think probably the answer is a bit of both. And I think this is one of the benefits of there have been efforts to educate lawyers about how to provide limited scope retainers, for example, sort of that semi-lawyered situation. In law schools, I can tell you this is something that increasingly we try to teach about. It's still an area that I don't think is taught across the board, but there are different skills for lawyers to have. One of those in that context, I would think, includes calling your lawyer on the day if they haven't been involved in the process at all is probably going to be suboptimal, because your lawyer may, respond as lawyers often do, which is to imagine worst case scenarios and imagine objections. Whereas having the lawyer involved even just a little bit and apprised earlier on in the process, I think can probably help to alleviate some of those concerns. So if the lawyer can see that this is a process that, for example, the mediator is engaging in designing a process to try and address the information imbalance that may exist, they may have more comfort later on to have a conversation with their client, otherwise SRL, and say, look, did you feel heard in this process? Here are my concerns, but you are the client for the purposes of this limited scope retainer. But that's just off the top of my head.
And there's some great comments showing up in the chat function, but we have reached the appointed hour, Andrew, and in a second, I'll again thank you for your time. I just want folks to know that the PowerPoint will be shared. The recording will be posted on the ADRIA website, so you can access all this and share it, or if you had to tune out early, you can catch it later. We'll also save the chat function, pass it on to Andrew. He might be able to send us back some answers to some questions he didn't get to, and we can forward those on to you. So I do invite the audience to use the chat function to express their appreciation for Andrew's time today. I too, I've thrown up the two websites there for the project and the Project West. Certainly there's always room there for donations for the good work that they do. Again, a reminder that we have another luncheon coming up, I believe, on June 8th, and a couple of AGMs for both the FOAJ and ourselves, and some great training opportunities. Andrew, this has been a really great presentation. I appreciate the time and effort you made to dig into what lawyers need to hear, digging into our ADR Canada Code of Conduct and Code of Ethics. That's very relevant to our audience today. Many of which, but not all, are members of FOAJ or ADRIA. I think it's been very, very useful. So you bring a lot of expertise to the table. We appreciate the work that you're doing. I had all kinds of questions about the impact of SRLs on courts, and we'll just have to dig into that on a different day. But again, my thanks to you, and actually last words to you.
Well, Paul, I just wanted to say thank you. Thanks to Karen FOAJ, and thanks to everybody for joining today. I hope you got something useful out of this. Appreciate it.
Great. Thanks a lot. And we'll see many of you back in the month of June. Take good care. Thanks.